Hey y'all, welcome back to TXT Tells All. So it's November 2021 and we're still dealing with COVID, particularly taking the COVID-19 vaccine, being allowed to work. If you don't want to take the COVID-19 vaccine, what happens if you get COVID? What can your employer do? What do they have to do? All those issues are still coming up, right? We're still living that. So I wanted to do an update. I did a video on COVID-19 and workers' rights a few months back, and I wanted to kind of follow up on that video and let you know what is the law saying about getting COVID and employers firing you. Can an employer fire you when you tell them that you got COVID? Can that happen? What's the law saying about it? Are there any cases out yet dealing with that issue? That's what this video is going to be about because, yes, as of October 6, 2021, a court in Pennsylvania had made a decision on a case moving forward where a worker got COVID-19, told her employer, and then he said, "You're fired." What happened? What did the court say about that? Watch this video if you want to know. So as you may or may not know, the law can move pretty slowly, right? And COVID is moving fast. So everybody has been waiting to see what the courts are going to say about lawsuits being filed by employees saying I was discriminated against, I was wrongfully terminated because I got COVID-19. This federal court in Pennsylvania has decided, at least in the early stages of the case, if a case should be dismissed or if it is allowed to move forward under the Americans with Disabilities Act and the state anti-discrimination law out in Pennsylvania, saying yes, this case about an employee being discriminated against based on COVID-19, they said this case can move forward. So the employer tried it, y'all. They tried to dismiss the case. An employee working in Pennsylvania told her employer she got COVID-19 in late November of 2020, and he basically just fired her. And the court, she filed a lawsuit saying she was wrongfully terminated and discriminated against based on a disability. And the employer came and said, no, that's not valid. COVID-19 is not a disability. We want the court to dismiss this case. And the court said, no, COVID-19 can qualify as a disability or at least a perception that the employee is disabled. So what that means is there's kind of two buckets under the Americans with Disabilities Act for wrongful termination cases. It's did the person actually have a disability, or did the employer regard that person as or perceive that person to have a disability? Both of them can form the basis for a disability discrimination case under federal law and most state laws. So that's what the court said. This employer heard the story of this employee telling them that she had COVID-19, and she even kind of reported some of the symptoms that she was having: loss of taste, loss of smell. And the employer said, you're fired for that reason. The court said this case is not going to be dismissed and it can move forward. So that happened October 6th of 2021. And this is one of the newer cases dealing with that issue. Is having COVID-19 going to be considered a sufficient basis for a disability discrimination wrongful termination case? This federal court in Pennsylvania said yes. So what does that mean? What it means is that courts may start deciding that under some circumstances, COVID-19 can qualify as a disability. And I want to read this for you y'all. The court in this Pennsylvania case actually said they relied on some guidance from a document from the Department of Justice, Health and Human Services. And it's titled Guidance on Long COVID as a Disability under the ADA, Section 504 and Section 1557. And that explains that because of some of the symptoms that COVID causes, including, like I said, loss of taste and smell, and that some of these symptoms are recurring for a longer period of time. So it's not just 2 weeks that people are experiencing COVID symptoms. Some people are experiencing COVID symptoms for months. And these symptoms actually do limit what's called major life activities, affects breathing, affects ability to walk, ability to run, ability to lift. if you've had COVID or you know somebody who does, people have been hospitalized because of COVID, and even people who haven't have had really serious symptoms that continue on for months and months, even when they're not testing positive for COVID-19 anymore. So what the courts are saying is, in situations like that where a person has these symptoms that can affect major life activities, that can qualify as a disability, just like another chronic illness would. So now it's not clean cut that COVID-19 is not going to be the basis for disability discrimination cases. And what I think is going to happen is, after this case comes out, now of course people are going to be filing other cases that, for employees who've gotten terminated because they told their employer they had COVID-19, and they're going to use this case as precedent, or they're going to use this case to say, as was shown here, the federal court decided that this case shouldn't be dismissed and should at least be allowed to move forward in the litigation process. The same thing may start to happen. So let's keep an eye out. I'll keep you guys updated on what's coming next. But if you're having issues and you think you may be fired, or you needing to tell an employer that you have COVID-19, make sure you watch my video on COVID-19 and how to possibly get a reasonable accommodation. Make sure you watch that, because that'll give you some good information on what to do if you're in a situation where you're fearful of getting terminated and you need to know kind of how to handle it, how to tell your employer, and what you should be looking for. If you like this video, make sure you hit the like button. Also subscribe to our channel. I'll be doing videos kind of keeping you guys updated on the law and COVID-19. Hope this helps. Thanks for watching TXC Tells All.